This conference will now be recorded.
Okay, you're welcome to go ahead and start.
Thanks very kindly. Can everybody hear me okay?
Yes.
Okay. So the time is 11:02 a.m. The September 9th, 2020 meeting of the State Medical Board will come to order with the following members present via video conference. Dr. Rothermel,
Present.
Dr. Safran,
Present.
Mr. Jacquelin,
Here.
Dr. Sohn,
Present.
Dr. Johnson. Dr. Johnson? Dr. Cacarella,
Present.
Mr. Ganatakis,
Present.
Ms. Becker,
Present.
and myself, Dr. Schottenstein. Do I hear a motion to approve the minutes of the August 12th, 2020 board meeting as drafted?
So
So
moved.
moved, Dr. Johnson.
Dr. Johnson, and I heard Dr. Safran. Thank you. All in favor? Voice vote? Aye.
Aye.
All opposed? Thank you. The board will now consider the report and recommendations appearing on today's agenda. Has each member of the board received, read, and considered the hearing record, the findings of fact, conclusions, and proposed order, and any objections filed in the matters of Abdallah Al-Shahad, MD, William Lewis Hauser, MD, Douglas M. Shad, LMT, and Denise Woodrum? Roll call, please. Dr. Rothermel,
Yes.
Dr. Safran,
Yes.
Mr. Jacquelin,
Yes.
Dr. Sohn,
Yes.
Dr. Johnson,
Yes.
Dr. Cacarella,
Yes.
Mr. Ganatakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Bechtel,
Yes.
and myself, Michael Schottenstein, yes. Further, does each member of the board understand that the board's disciplinary guidelines do not limit any sanction to be imposed, and that the range of sanctions available in each matter runs from dismissal to permanent revocation or permanent denial? Roll call, please. Dr. Rothermel,
Yes.
Dr. Safran,
Yes.
Mr. Jacquelin,
Yes.
Dr. Sohn,
Yes.
Dr. Johnson,
Yes.
Dr. Cacarella,
Yes.
Mr. Ganatakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
and Dr. Bechtel,
Yes.
and myself, Michael Schottenstein, yes. Does each member of the board understand that in each matter eligible for a fine, the board's fining guidelines allow for imposition of the range of civil penalties from no fine to the statutory maximum amount of $20,000? Roll call, please. Dr. Rothermel,
Yes.
Dr. Safran,
Yes.
Mr. Jacquelin,
Yes.
Dr. Sohn,
Yes.
Dr. Johnson,
Yes.
Dr. Cacarella,
Yes.
Mr. Ganatakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Bechtel,
Yes.
and myself, Michael Schottenstein, yes. In accordance with the provision in Ohio Revised Code 4731.22F2 specifying that no member of the board who supervises the investigation of a case shall participate in further adjudication of the case, the secretary and supervising member must abstain from further participation in the adjudication of any disciplinary matters. In the disciplinary matters before the board today, Dr. Rothermel served as secretary and Dr. Safran served as supervising member. In addition, Dr. Bechtel served as secretary and/or supervising member in the matter of Dr. Al-Shahad. During these proceedings, no oral motions may be made by either party. Finally, respondents and their attorneys addressing the board will be allotted 5 minutes to do so. The board parliamentarian will advise when the 5 minutes has expired. The assistant attorneys general will be subject to the same limitations. Please turn to the matter of Abdallah Al-Shahad, MD. No objections have been filed. Mr. Porter was the hearing examiner. Is there a motion to approve and confirm the proposed findings of fact, conclusions, and order in the matter of Dr. Al-Shahad? Motion.
So moved, Dr. Johnson.
Thank you. And
Cacarella, second.
Dr. Earl, thank you so much. I will now entertain discussion concerning the matter of Dr. Al-Shahad. Is there any discussion? So I guess I'd have a bit of discussion. You know, by all accounts, this is a good doctor, right? He's competent and professional and compassionate and well-respected. So when we see a doctor engage in behavior that is so clearly inconsistent with that profile, it begs the question as to why. I'm not really sure even the doctor himself knows the answer to that question. I think the behavior of the doctor hinges on his pre-existing relationship with the nurse. This was someone he had known for years, who'd been his contact person at the nursing facilities where he worked. He respected her as a professional, and he appreciated her help. He'd come to trust her, and I think his trust impaired his judgment and caused him to rationalize behavior that he otherwise would not have. When he got that call from the pharmacist, I think he experienced cognitive dissonance. Here he was faced with a clear forgery of a prescription, made out to the nurse and signed by him. But he believes the nurse to be an honest, professional, helpful person. These two beliefs are dissonant. They don't go together, and that provokes psychological stress. So he found a way to resolve this stress by resolving the contradiction. I think he did so by conceptualizing the situation as a mistake of some sort. Remember what he told the pharmacist on that call. There must be some confusion, he said, because the nurse is the director of nursing at one of the nursing homes. And he rectified this perceived mistake by doing what he thought was the right thing at the time, based on a feeling of sympathy for her, knowing she was in pain, but coming to work anyway and fighting through it. So he allowed a smaller quantity of the medication to be dispensed. And to his credit, when he realized his trust was misplaced and his rationalizations broke down, he spoke up regarding his own behavior with the pharmacist. He blew the whistle on himself. He could have kept this incident to himself, but his first priority was arguably the safety of the patients. In the transcript of the hearing, I think the doctor shows remorse and humility and takes responsibility for his actions. He remediated his behavior by taking controlled substance and medical ethics courses. He has no prior disciplinary violations, and there was no dishonest or selfish motive for his behavior. He's been cooperative throughout the process. I think the situation is highly unlikely to recur. So I agree with the proposed order. Is there further discussion?
Mr. Schott, Dr. Schottenstein.
Yeah.
I think this has been amended. The fine, the reprimand, and then the fine is 500. Is it now proposed?
That's a different case. That's Miss Woodrum. She's
Okay.
coming.
I think the fine is too large. And unless my notes are wrong, it's an $18,000 fine proposed,
That's right.
and that troubles me. And
Okay.
I have a question regarding, I couldn't agree with you more about the cognitive dissonance. And I do have a question about the 3 years here. We've had numerous, and it raises the question, which we're now, I think, going to address, is what is our policy on continuances? Who sought the continuances here? Is this an AG request? Is this a medical board request? Is this a doctor request? Can anybody answer that?
Anybody want to weigh in on that? I'm not sure the answer to that question.
Because we have at least 3 or 4, at least 3 continuances, and this is dragged out for 3 years. I think my timing is approximately 3 years. So it does bring us back to the question of how do we tighten up timeframes, because it's not fair to the doctor, nor is it fair to whomever brought the complaint, however they brought the complaint, nor the public. So it's just a notation. Rebecca, do you know where the continuances came from?
They would have been, once the site's issued, that's all handled between the AGs and the doctor. So the AGs would have to respond to that for you.
Okay, so Emily, do we know where the continuances happened or why?
I'm looking back through, and again, this case is from a while ago. I can find that information, perhaps let you know at another time, but what I can say is that the doctor was represented by counsel, and continuances were perhaps made pending settlement of the cases that the case that might not have gone through, or other reasons. But counsel was the doctor was represented by counsel. So,
Thank you.
That really doesn't really answer the question of delaying a case 3 years. So if you can find that out, Emily, that would be most appreciated, and let us know. That's my only comment. I think we should entertain a reduction on the fine. He doesn't present as as somebody who is going to be a danger going forward, and for the reasons you well articulated, I would respectfully request that we reduce the fine to a level that's appropriate. I don't have a context of a long-standing, where do we go on these things? So somebody else might want to jump in. Perhaps this is a $2,500 fine or something like that. Again, I don't have would appreciate any advice on that, but I just would respectfully request that we amend the R&R to include it. Let me just give you a number and then we can talk about it. I would forward a motion to amend the fine to $2,500.
Second.
Forgive me, was that Dr. Feibel that seconded that?
Yes.
Okay, thank you so much. And Dr. Feibel, you had your hand up.
I was going to suggest that.
Great. Is there further discussion?
Michael?
Yes, sir.
I would agree with everything that's said. I think Doctor, it was bad judgment in this case, but understandably so. The one comment I would have in terms of the defense attorneys somehow trying to shift blame to the pharmacist on the corresponding responsibility piece, I think is a total red herring. I don't even understand how that's even justifiable in terms of making that argument that all of a sudden it's that individual's corresponding responsibility to block the script because they thought it was fake. I mean, come on. Where are we going with that argument? That's total fallacy. That's still, the onus is on the physician to decide whether the legitimacy of their own prescription. But that being said, I would agree with everything that's said. I think this is a good physician. I think he's got a great track record. Obviously, he's there for his family. I mean, there's so many positives here. I just don't see us, hammering him on. That's it, Michael. Thanks.
Thank you so much. Further discussion? Okay.
I am not supportive of a fine reduction. I think at the end of the day, he authorized for the prescription of, pills to be filled, despite knowing that the prescription was, as presented, was fraudulent. And, I don't know. I'm fine with the fine of $18,000 in that scenario.
Thank you so much, Dr. Sloan. Is there further discussion? Okay. So if you'd all be so kind, maybe let's have a roll call vote on the amendment to reduce the fine to $2,500. Do I hear a motion to approve and confirm? Sorry, forgive me, a roll call vote. Dr. Rothermall.
Abstain.
Dr. Safran.
Abstain.
Mr. Giacalone.
Yes.
Dr. Sohn.
No.
Dr. Johnson.
Yes.
Dr. Coccarella. Sorry, forgive me, Dr. Coccarella. Sorry, yes or no, Dr. Coccarella? Oh, I think I hear him saying no. Can't really hear his volume, but I think that was a no.
It looks like a no. Correct.
Okay. Mr. Gandadakis. No, it's
No.
quite all right.
No.
Mr. Gandadakis votes no. Ms. Montgomery.
Yes.
Dr. Feibel.
Yes.
Dr. Bechtel.
Abstain.
And myself, Michael Schottenstein, no. Where does that put us, Benton? If you
Under counting of the votes, there are 4 yeses and 4 noes. Without receiving the majority, the amendment does not pass.
Okay, thank you. Is there further discussion?
Michael, can I make another amendment? Let's split the difference, 9,000.
Okay, we have an amendment to increase the fine to $9,000. Is there a second?
Second.
Ms. Montgomery, thank you. Is there further discussion? Okay, we'll have a roll call vote on a reduction of the fee to $9,000. The fine, I should say, to $9,000. Roll call, please. Dr. Rothermel.
Abstain.
Dr. Safran.
Abstain.
Mr. Giacalone.
Yes.
Dr. Sohn.
No.
Dr. Johnson.
Yes.
Dr. Coccarella.
No.
Mr. Gandadakis.
No.
Ms. Montgomery.
Yes.
Dr. Feibel.
Yes.
Dr. Bechtel.
Abstain.
And myself, Michael Schottenstein, no. Where does that put us, Benton? Please.
That is the same vote as 4 in favor and 4 against, and not having received a majority, the amendment does not pass.
Thank you. Further discussion? Okay. So maybe if you'd be so kind, then we'll take a roll call vote on the proposed order to approve and confirm the proposed findings of fact, conclusions, and order as presented in the matter of Dr. Al-Shahad. Dr. Rothermel.
Abstain.
Dr. Safran.
Abstain.
Mr. Giacalone.
Yes.
Dr. Sohn.
Yes.
Dr. Johnson.
Yes.
Dr. Coccarella. Sorry, Dr. Coccarella.
Yes.
Thank you. Mr. Gandadakis.
Yes.
Ms. Montgomery.
Yes.
Dr. Feibel,
Yes.
Dr. Bechtel,
Abstain.
and myself, Michael Schottenstein, yes. Thank you. Please turn to the matter of William Lewis Hauser, MD. No objections were filed. Szymanski was the hearing examiner. Is there a motion to approve and confirm the proposed findings of fact, conclusions, and order in the matter of Dr. Hauser?
So moved.
My goodness. Let's see, Dr. Johnson, and a second, please. Dr. Bechtel, thank you so much. I will now entertain discussion concerning the matter of Dr. Hauser. Is there any discussion? So, before I talk about the case, I want to mention a small discrepancy that I found in the discussion of the proposed order. I brought it to hearing examiner Szymanski's attention, and she asked me to share it with you at the meeting today. Under the discussion of proposed order, it states that the doctor failed to pay his taxes during the quarters ending September 30th, 2009 through December 31st, 2015. That actually should state September 30th, 2009 through December 31st, 2014. It makes a difference because if it were truly through 2015, then we could have imposed the fine for that time after September 29th, 2015. Earlier in the R&R, the dates are noted correctly. So the hearing examiner, I think, correctly noted that the doctor committed a very serious offense by failing to pay his income taxes over a period of several years. He went on to note that there are many mitigating factors, such as being cooperative and remorseful and compliant with his criminal sentence. He noted that he was a skilled and compassionate physician, and I believe that. I guess what concerns me, though, is that in addition to these mitigating factors, there are also aggravating factors in this case. The doctor had selfish motive. There's a pattern of misconduct where he did not pay taxes over a period of years. I think this behavior has an adverse impact on the public because it dilutes the shared sense of civic obligation and it dilutes respect for the law. In addition, the behavior was reckless. He knew it was wrong, but he did it anyways. So we are in a bit of a position because to suspend the license would substantially impede his ability to pay his restitution, and not just during the suspension. Because he's a solo practice doctor, many of his patients would likely find care elsewhere. So even after the suspension, he would be in that much more of a difficult financial position from the loss of business with the same expenses and obligations. So I think under the circumstances, I would amend the order to a 90-day definite suspension, but then stay the suspension. I think it's a step up in discipline from the reprimand, but it also preserves the ability to continue to pay restitution to the government. So as president, I can't make that motion. If anyone else is inclined to do so, I'd be glad to entertain it.
I'd like to make that motion, Dr. Bechtel.
Dr. Bechtel, thank you. Is there a second?
I'll second for discussion.
Thank you so much, Mr. Jacqueline. Is there further discussion then?
Yes, I actually initially was supportive of the reprimand, although I'm happy to discuss Dr. Schottenstein's motion. And my thinking was that, a lot of this was more of a kind of a financial transgression and not necessarily things with patients. And I suppose I guess I can sympathize with some of the mitigating factors of, trying to run your own practice, being a physician and doing that, not having a lot of formal training and a lot of the financial aspects, but then, being thrown into being a small business. And that I understand he broke the rules and law and that's terrible, but I do appreciate some of the mitigating factors. I also appreciate that he's provided, nearly 40 years of service to an underserved community in Youngstown. That's nice as well. I wanted to make those comments, although I am open to Dr. Schottenstein's opinion as well.
Thank you, Dr. Sloan. Dr. Feibel.
Yeah, I am supportive of the reprimand as opposed to the modification for Dr. Soin's reasons. I think in this case that is enough. And I think Dr. Schottenstein, you said it's the same punishment. I know on paper it's not, but I think it's a dangerous thing to start. I haven't been on board long enough, but I don't love the 90-day suspension with the stay, so I'll support the reprimand.
Thanks very kindly. And Mr. Jacqueline.
It seems like we have this philosophical discussion every few years on whether financial wrongdoing, for lack of a better word, constitutes, physician wrongdoing per se. And I know Dr. Schottenstein would say arguably yes, this one I'm kind of on the fence on. I mean, I don't see how mismanaging your office and relying on your office manager who supposedly took a wrong turn for you and you started down the path equates to bad physicianing or bad practice of medicine and hurting patients. If anything, this individual didn't do that. It was just the opposite. So I guess I'm a little bit struggling when we reach these cases. What, if any, is the amount of punishment for something that really arguably doesn't fall into the practice of medicine? But arguably you could say it's a moral turpitude issue, right? But again, this one, it's not as clear for me. So I guess I'm really kind of go either way. If there's not really much difference, I could see the reprimand. So I'm kind of on the fence, but that's my 2 cents. That we seem to cross this bridge every so often, and here we are again.
Sure. Dr. Soon.
Yeah, and that's just it. I feel the same way about these financial things because keep in mind, these people are already being punished, right? I mean, Dr. Hauser is being punished for this crime through other means, right? I mean, it's not necessarily, in terms of us staying in our lane of what's appropriate for us in terms of protecting the public, which is why I think a reprimand is fine. I mean, clearly what he did was not great. It clearly was within the practice of his own practice of medicine. And the reprimand will affect him substantially, right? He'll end up on the National Provider Database as having a reprimand. He'll have to report that when, he fills out applications for stuff and hospital credentialing and insurance credentialing and stuff. So, I mean, this is something that will continue to stick with him, as a form of punishment, so to speak. On that note, I am, content with a reprimand in this case.
Thank you so much. Is there further discussion?
Michael,
Yes.
one question. Is there an ethics course involved in this anywhere? I wasn't sure. Is it just a straight up reprimand?
Yeah, I think it was just a straight up reprimand.
I mean, I could see maybe amending the order to include an ethics course along with the reprimand.
I would support that.
I'm sorry, what was your,
So amend the order to reprimand, but include an ethics course, professional ethics course.
Sure. So if nobody has any objection, I'll modify the amendment to take away the proposal for the state suspension, leave it as a reprimand, but include an ethics course. Does that sound okay?
Dr. Schottenstein, do you want to include a time frame when he needs to complete the ethics course? Since it's a reprimand, there's no probation.
Maybe let's say within a year.
Okay, thank you.
Okay, thank you so much. Do I need additional motions for the substituted language, or we're all okay?
There were no objections from board members, so it's okay. But I do want to make sure that I understand, Dr. Schottenstein, that you are removing the state suspension and adding the ethics course with the 1 year time frame to complete. Is that correct?
That's correct. So there will still be a reprimand with the ethics course.
Okay, yes. In the absence of any objections from board members, the amendment stands as you just stated it.
Great, thank you so much. Further discussion? Okay, so if you'd be so kind then, let's have a roll call vote on the amendment. Dr. Rothermel?
Abstain.
Dr. Safran?
Abstain.
Mr. Jackalone?
Yes.
Dr. Soen?
Yes.
Dr. Johnson?
Yes.
Dr. Kakarada?
Yes.
Mr. Ganadakis?
Yes.
Ms. Montgomery?
yes,
Dr. Feibel?
Yes.
Dr. Bechtel?
Yes.
And myself, Michael Schottenstein, yes. Do I hear a motion to approve and confirm the proposed findings of fact, conclusions, and order as amended in the matter of Dr. Hauser? Motion, please.
So moved, Dr. Johnson.
Dr. Johnson, and I saw Dr. Kakarada. Thank you. Oh, thank you. Before voting on the motion to approve and confirm as amended, is there any further discussion? Okay. Roll call, please. Dr. Rothermel?
Abstain.
Dr. Safran?
Abstain.
Mr. Jackalone?
Yes.
Dr. Soen?
Yes.
Dr. Johnson?
Yes.
Dr. Kakarada?
Yes.
Mr. Ganadakis?
Yes.
Ms. Montgomery?
yes,
Yes.
Dr. Bechtel?
Yes.
And myself, Michael Schottenstein, yes. Thank you all. Please turn to the matter of Douglas M. Schott, LMT. No objections were filed. Ms. Szymanski was the hearing examiner. This matter is non-disciplinary in nature, and therefore all board members may vote. A request to address the board has been filed on behalf of Mr. Schott. 5 minutes will be allowed for that address. Sir, you may go ahead if you can hear me okay.
Okay. Yeah, I had unmute. I forgot to unmute. I'm sorry.
Yeah, no worries.
Okay, I wanted to take this time to bring up 3 points. One thing I wanted to put a name to the face that may help me or hinder me. I'm not sure. You guys can be the judge of that. And also, I would like to say that you're giving me an opportunity to bring something back into my life that I cherished that I couldn't do before because I had back surgery and it didn't go well. And there's one other point I really want to make, and that is that through this whole thing, I want to commend your staff. Your staff helped me and navigated me through this process, which I was kind of afraid of at the very beginning, but they made it very comfortable for me. And I want to thank you, and I want to thank them. And that's all I have to say.
Thank you for your
Thank you.
thoughtful comments, sir. Would the Assistant Attorney General like to respond?
No, thank you. Thank you.
Thank you very much. Is there a motion to approve and confirm the proposed findings of fact, conclusions, and order in the matter of Mr. Schott?
So moved.
Ms. Montgomery, and I saw Dr. Bechtel's hand up. Thank you. I will now entertain discussion concerning the matter of Mr. Schott. Is there any discussion? So it sounds to me like the gentleman has been a fine massage therapist. And I'm respectful of his argument that he's engaged in self-study and tried to keep his skills sharp by providing massage without compensation. But regrettably, I don't feel like those activities adequately address my concerns under 4731.222. I have more faith than he does that with his experience and knowledge that he'll be able to take and pass the NBLEX. It's going on 7 years now since he's had a license. I'm not familiar with the materials he's using for self-study, and his practice of massage appears to have been minimal over that time. I think that it's common to feel intimidated by a test, but I think it creates a double standard to just grant the license because I think everyone who has to take the NBLEX is intimidated by it. And if he truly feels like at 67 years old that by definition, because of his age, that he's not cognitively sharp, I think that's concerning. I think if anything, then you'd want to verify that your cognition is sharp if you're going to start practicing massage therapy on the public, and passing the test would give some reassurance to the public and to the licensee to that effect. So my thought would be to amend the order to require the gentleman to take and pass the NBLEX as a condition of the granting of his license. As president, I can't make that motion. If anyone else is so inclined, I'm glad to entertain it. Dr. Feibel, thank you.
Yes, I full-heartedly agree and was going to talk about the same stuff. So I will be happy to make the motion that he should have to pass the NBLEX within 6. Well, I guess
Usually 1 year.
Well, 1 year. Okay, then within 1 year of this hearing, I feel that it's a dangerous precedent to set, even if he is competent to practice. We all feel he might, he is competent, and it is a dangerous precedent to set. And so I would go, I would feel much better with him passing that block.
Thank you
I'm
so
sorry,
much.
was there a second to Dr. Feibel's motion to amend?
Right, I was just going to ask if there's a second.
Second.
Dr. Saffron, thanks so very much. Is there further discussion? Mr. Giacolone.
I guess this one I'm on the other side of the fence, and I typically wouldn't be. First, I mean, the legislation provides the mayor board may. So it's our prerogative whether we want to impose the complex on them or not. So there isn't a hard and fast rule on that. Maybe precedent, yes. Secondly, I think it's a little different too. We're not talking about a brain surgeon here. No offense to the massage therapist, but we're not talking about a brain surgeon. We're talking massage therapist, okay? And I think, my experience, and maybe this holds for other people, maybe not, to teach something, you really need to know it. I mean, you can't wing it. You have to know it. And I think this individual has taught it, for a number of years. And he's done it on the side. Yeah, not the routine that we would prefer, obviously. But I think this is a somewhat unique situation that I think merits perhaps a different look. I hate to be hard and fast on everything. I mean, then why do we need us? Just rubber stamp it and move it along. You don't need to even have this hearing. But I think, the Mace scenario in this is our choice. And secondly, and it isn't rocket science and brain surgery. So I propose granting him the license, quite honestly. That's my 2 cents. Thanks.
Thank you so much, Mr. Giacomo. Are there further comments? Okay, so let's have a roll call then, please, on Dr. Feibel's amendment. Dr. Rothermel,
Yes.
Dr. Safran,
Yes.
Mr. Giacomo,
No.
Dr. Sohn,
No.
Dr. Johnson,
Yes.
Dr. Cagarella. Sorry, Dr. Cagarella?
Yes.
Yes, thank you. Mr. Ganadakis. Sorry, Mr. Ganadakis.
Sorry. No.
Ms. Montgomery,
No.
Dr. Feibel,
Yes.
Dr. Bechtel,
Yes.
and myself, Michael Schottenstein, yes. Benton, where did that leave us, please?
There are 4 nays and 7 ayes. The motion to amend passes.
Thank you very much. Do I hear a motion?
Sorry, what was that?
Mhm.
What was
It was 7 votes in favor and 4 votes against.
So, Michael, just reiterate, what is the one we're voting on now? So we're all aligned.
Right, of course. So this is the amendment by Dr. Feibel to revise the order so that the gentleman would need to take the MBLEX. Okay. Do I hear a motion to approve and confirm the proposed findings of fact, conclusions, and order as amended in the matter of Dr. Schott? Mr. Schott, sorry. Motion?
So moved.
Dr. Safran and
Second.
Dr. Feibel. Thanks very much. Before voting on the motion to approve and confirm as amended, is there any further discussion? Okay. Roll call, please. Dr. Rothermel,
Yes.
Dr. Safran,
Yes.
Mr. Jekyll,
No.
Dr. Sohn,
No.
Dr. Johnson,
Yes.
Dr. Cacarella. Sorry, Dr. Cacarella. It was a yes. Mr. Rodakis,
No.
Ms. Montgomery,
No.
Dr. Feibel,
Yes.
Dr. Bechtel,
Yes.
and myself, Michael Schottenstein, yes. Benton, does that pass?
Yes, it does pass. 7-4.
Thanks very kindly. Thanks, everybody. Please turn to the matter of Denise Woodrum. Objections have been filed and were previously distributed to board
Thank you,
members.
Dr. Douglas, Mr. Schad. We need to get him off the, thank you, Mr. Schad.
Thank you.
Yeah,
Okay.
sure. Thank you so much. Objections have been filed in the matter of Ms. Woodrum and were previously distributed to board members. Mr. Porter was the hearing examiner. A request to address the board has been filed on behalf of Ms. Woodrum. 5 minutes will be allowed for that address.
Morning, Mr. President, members of the board. We certainly thank the board for the opportunity to present here this morning. And we thank Mr. Porter for his very thorough report and recommendation. I did file objections to that, which I'm sure the board has reviewed. I would just like to reiterate that without a finding of criminal intent, it's not appropriate to find that Ms. Woodrum committed a felony in this matter. This case is definitely unique in that, unlike other limited practitioners, she wasn't on her own working out of her house. She was part of a team, and she was working with licensed dermatologists. So we would certainly request that the board consider that distinguishing factor into its analysis as it's reviewing this case. I would just also like to kind of point out that when Ms. Woodrum learned that she did not have an active license, there was a period of time where, out of fear of abandoning patients, she did work 1 day a week to address the patients that were receiving the electrolysis treatment. And she understands now that she should not have, she should have stopped. But it was not through an act of defiance, but it was really out of, I want to say, appreciation for her patients and a willingness to not just discontinue care in a field that kind of lacks adequate service. But we thank the board. She is very truly sorry. And with that, I turn the balance of the time over to Ms. Woodrum.
I'm really sorry that I have caused all this inconvenience for the board. I'm embarrassed. It's been disgraceful to me that I've ended my career this way. I've worked for dermatologists for 30 years, but in healthcare for 40, never had any problems at all. I love my job. I wish I could get my license back. I have a lot of clients in Cincinnati. There's not that many electrologists, so there's a need, there's a business there for electrolysis, and I would really appreciate to get my license back and continue. I'm 65, single, and living on Social Security, and it's just not enough. And I realized what I had done was wrong, but I didn't realize it. So I really would like to get my license back and get back to work because I feel there's a need in a business there. I work with a lot of transgender community. I've worked with PCOS, and a lot of doctors refer to me, and I would just like to get back the respect that I had in town and never do this again. I'd be happy to pay my fines, fees, and if any continuing classes that I need to, especially at the time of COVID. So I appreciate careful consideration to my circumstance because I'm truly, truly sorry that this has happened.
Thank you so very much. Does the Assistant Attorney General wish to respond?
Thank you. Just very briefly, I would like to thank Counsel and Ms. Woodrum for engaging in the hearing. I did find that she was forthcoming when she testified. And I think the main thing that we need to focus on here is that we just needed to prove that she practiced without a license for a period of time, which is something that she admitted to. We don't have to show that there was a mens rea requirement here. All we needed to do was show that she did not practice. She was responsible for knowing the status of her license at that time. And quite honestly, I know that I'm diligent when it comes to making sure this is up to date and on time. So that is the requirement of the individual and the responsibility of the individual to make sure that their license is up to date and current. So I just want to be sure that we are not saying that we need to find this mens rea requirement when we're finding an act constituting a felony, and that she has admitted that she did not have proper licensure during that time. And I'd ask that you adopt the hearing examiner's report and recommendation. Thank you.
Thank you so much. Is there a motion to approve and confirm the proposed findings of fact, conclusions, and order in the matter of Ms. Woodrum?
So moved, Dr. Johnson.
Thank you. Is there a second?
Second, Dr. Bechtel.
Dr. Bechtel, thank you. I'll now entertain discussion concerning the matter of Ms. Woodrum. Is there any discussion?
Michael, I want to make a proposed amendment to this. And I think you already sent it around. It's your proposed, the one that you suggested for, let's see, what was it? Grant the licensure to suspend for 180 days and a $1,700 fine with an active course. So that's what I'm proposing that we do, as opposed to the permanent revocation, $18,000 fine, and denial.
Thank you very kindly. So we have an amendment from Mr. Giacalone. Is there a second? Okay. Well, so Mr. Yonadakis?
I'll second it.
Okay, thank you very kindly. So is there discussion?
Can
So
you clarify the amendment for me, just so I'm clear?
So actually, Mr. Giacalone, in that regard, can be more specific about it. I had just a few more thoughts I was going to discuss, if now's a good time. So I guess first off, though, I would respond to defense counsel's objection that Ms. Woodrum can't be guilty of committing a felony because she lacked felonious criminal intent. You know, and in the objections, we were encouraged to reject conclusions of law 2 and 2A. So 4731.41, it's not a strict liability offense. It doesn't specify any specific level of culpability. So in cases like that, the default required level of culpability is recklessness, which is to say, if we believe Ms. Woodrum's conduct, which gave rise to a violation of 4731.41, was reckless, then the B10 violation is found. I believe that Ms. Woodrum's conduct was in fact reckless. I think it was reckless of her to take the word of a supervisor that her license was grandfathered and never bother to check the veracity of that statement, either immediately or in the following 24 years. I think she was heedlessly indifferent to the consequences of her failure to verify important aspects of her licensure. I think her behavior represents a gross deviation from what a reasonable law-abiding person would do. So I'm respectful of defense counsel's argument, but I think conclusions of law 2 and 2A apply in this case. So that said, I'm respectful of the hearing examiner's order to deny the license, but as he himself pointed out, the board has limited branch licensees who from time to time fail to renew their licenses in a timely manner, and we typically suspend them for 90 days or 180 days. It's really only because of the profound length of time of practicing without a license that the proposed order was to deny the license. So I was thinking about an amended order, which was circulated, to restore the license and a definite suspension for 180 days. I appreciated defense counsel's thought about making the suspension retroactive, but my thought is that by not making it retroactive, by the time Ms. Woodrum is able to practice, she will have been out about a year. I think that's about right, considering the length of time that she was in violation of her licensure responsibilities. She should complete a professional ethics course within a year of completion of the suspension and fulfill her required CME. There should be appropriate interim monitoring terms, such as quarterly declarations and meetings with the board staff. I think her probationary status may end when she's fulfilled her course and CME requirements and paid her fine. And as per testimony, she's in arrears by $1,200 regarding her license renewal fees. The revised proposed fine is $500. I guess my thought is I would amend the fine to $1,700. So that's my proposed amendment. As president, of course, I could not make that motion, and so I'm grateful to Mr. Giacalone for making that on my behalf. And I'm trying to recall, did we have a second? Mr. Gandadaka seconded. Thank you. Is there further discussion then on Mr. Giacalone's amendment? Dr. Feibel. Oh, sorry. Ms. Montgomery, go ahead.
Then he can go, yeah.
So you're seeking to change the dates to make it appropriate to this sort of an errata. You're seeking to suspend for 180 days, but grant the license. You're seeking an ethics within a year. Ethics, you're thinking you're going to require quarterly reporting. So does that require probation?
So during this period of time, until she's fulfilled her requirements, she'll be on probation. But as soon as she's fulfilled her requirements, the probation will end. So during that time, she'll check in with the board.
So we would just have to, do we have to articulate that, or?
It's actually articulated. If you look in the onboard under her case, there's an amended proposed order, and it's actually in there.
Okay, so you're following the process, Dr. Schottenstein, you're following the process that you've previously used. We're having some difficulty with it because we are virtual and not in real, in person. But what would normally happen is this would be the point in time where an amendment would be passed out to the board for review. And so that's what you're doing here. Okay.
And then a $500 fine.
So
that's the amendment we're looking at.
So the hearing examiner revised his proposed fine to $500. My thought was, given the fact that she's also in arrears by $1,200, I just combined the $1,200 and the $500 and called a square. So for a $1,700 fine.
Oh, $1,700 fine. Mm-hmm.
Yeah, that seemed fair to me. Further discussion? Dr. Feibel, I think you had your hand up before.
Yeah, I am not in favor of this amendment, and I'm troubled by this case. This is not my license lapsed. I didn't, I missed the deadline by 3 months or even a year. This is a long-standing lapse of her license. She reapplied for her license and checked no on the box. I got to find the exact what it said. Hold on 2 seconds for me. Have you ever practiced, advertised, announced yourself as a practicing, or conducted an office for practicing cosmetic therapy while not holding a valid license from the State Medical Board of Ohio or from any other licensing agency. She had to know that she was doing that if she reapplied for a license, and yet she checked no to that. I'm troubled by all of that. I don't think this is your standard, oh, I forgot to renew my license type of situation. And then her veracity, I somewhat question when she came forward. So for that reason, I won't be supporting the amendment.
Thank you, Dr. Feibel. Is there further discussion? Okay. So if you'd be so kind then.
Michael?
Sorry, Mr. Jekyll, yes.
Yeah, again, this gets back kind of to the last one too, right? I mean, we're not talking about a brain surgeon here. We're not talking about a brain surgeon. We're talking about a cosmetic therapist. Yeah, not the greatest judgment. No argument there. You know, she relied on people and did it, and then she worked one day after, and those are all counter to having her get her license. But this just seems heavy-handed to me in terms of the penalty. I guess I struggle a little bit with, is this really the death sentence or something like this? I mean, is this what we think? That her career is done because of this? Gosh, if that's the case, I wonder what the line is for us. So I don't support this. I don't think permanent revocation is acceptable. I agree with Dr. Schottenstein. Should there be punishment? Yeah, absolutely. I just don't see it falling on something like this. That's it, Michael. Thanks.
Thank you so much. Further discussion?
I have to agree. I think we're a little heavy-handed here. I certainly appreciate all that you said, Dr. Schottenstein. But I worry about what appears to be will be a 6-month suspension and a $1,700 fine and the cost of ethics on at a time when if this were a different specialty, I would be wholeheartedly with you. But I think what we're doing is we're saying to somebody who is retired and on Social Security, we're not going to permit, we're going to pile on the money so much that it's going to be difficult be able to practice. I don't know that. I think we just look a little heavy-handed, with all due respect, because I do think that if we're another specialty, all bets are off. But this is not, a specialty requiring enormous education. For that regard, I have to agree with Mr. Giacalone.
Thank you so much, Ms. Montgomery. Dr. Feibel?
Yeah, the only thing I'd like to say to that is we have, the rules are there for a purpose. Whether you're doing neurosurgery or whether you're doing cosmetic therapy or whether you're doing respiratory therapy or anything else, I think we expect our licensees to follow the rules the same way. And so I think we need to get past that part of it. Whether you agree with the amended rule or not, I think we have to get past that. And we expect, I think the message to the licensees around that we regulate are that we expect you to comply with the rules of licensing. And whether you're any of those specialties, we're going to expect the same thing out of you. If this had been a physician who practiced without a license, I don't think we'd be making the same decision
And
here.
I agree with you. May I just comment on one thing? I think this is a fair statement, and please, I'll stand corrected by whomever on the board. I am not as offended by the lapse for as many years based on what I think most office managers' responsibilities are for example, in the practice of law, and that following, I realize we all have individual responsibilities, but generally speaking, I think this is a fair statement that it is, in a practice, not when she's doing it herself, but in a practice, there is the whole licensure question is followed by the practice, not the individual, albeit I know it's the individual's responsibility. And so I'm not quite as offended than if she were an independent contractor for that lapse. Should she have relied upon a more senior member of her practice? No, but that's a judgment call. So that's why I'm not as offended, and I agree wholeheartedly with you, Dr. Feibel, that if this was a doctor, that's a whole different kettle of fish than it is for a cosmetic therapist.
Thank you so much, Ms. Montgomery. Mr. Gunadakis.
Just regarding the proposed fine in Bob's motion, which I seconded, it's really just, if you think about it, just $500 in new money, if I'm understanding it correct. The other $1,200 is what she should have paid to the board to begin with. So really, it's a $500 fine, and then we're recouping money that should have been paid to the board to get us to the $1,700, which, yes, it is $1,700, but if we look at it that way, I think it's a little less heavy-handed.
Thank you so much, Mr. Gunadakis. Further discussion?
One last thing, I think, Michael, I think
Yes,
Montgomery raises a good point. I mean, what's the benefit to the public? Yeah, you can hold her up as the quintessential example, or is it better to get her back working in the profession and doing something productive as opposed to being unemployed? I don't, especially again, given the magnitude of what we're talking about here, we're talking about a cosmetic therapist, we're not talking about a physician, we're not talking about anything along that line. So I just see the pros on getting her back with the ability to come back with the penalty, right? She's not going to clear a clean slate here or walking away with nothing, outweigh the concept of, okay, you can never practice again. I just don't see the value in that. And quite honestly, is it a deterrent too to people reporting later on, self-reporting, because now they're going to go, well, shit, if that's the case, well, I'll just keep doing it. Don't even bother. So I think, that's something we should keep in mind too, as we're weighing the positives and negatives of what this represents to our licensees, is to say, I'm going to hide it from now on because I don't want to take a chance to never have my license, or am I be forthcoming and basically own up to it? So again, I see that as a positive in terms of the lesser sentence. Thanks.
thank you so much. Further discussion? Okay, let's have a roll call vote then, if you'd be so kind, on the amendment. Dr. Rothermel.
Yes.
Dr.
Abstain. Sorry.
Abstain. Dr. Safran.
Abstain.
Mr. Giacalone.
Michael, just to clarify, this is for the amended.
The amendment.
Okay, yes.
Dr. Sohn.
Yes.
Dr. Johnson.
Yes.
Dr. Coccarella. Dr. Coccarella? Oh, that's a yes. I can see him shaking his head. Ms. Montgomery.
No.
Dr. Feibel.
No.
Dr. Bechtel.
Yes.
Myself, Michael Schottenstein, yes. Do I hear a motion to approve and confirm the proposed findings of fact, conclusions, and order as amended in the matter of Ms. Woodruff? Motion, please.
Move.
Mr. Giacalone, and
Second, Dr. Johnson.
thank you, Dr. Johnson. Before voting on the motion to approve and confirm as amended, is there any further discussion? Mr. Gondadakis.
You skipped over me, but I do vote yes.
Forgive me. Thank you so much. Any further discussion? Okay, roll call, please. Dr. Rothermel.
Abstain.
Dr. Stafford.
Abstain.
Mr. Giacalone.
Yes.
Dr. Sohn.
Yes.
Dr. Johnson.
Yes.
Dr. Coccarella. That was a yes, I think. Mr. Gondadakis.
Yes.
Ms. Montgomery.
No.
Dr. Feibel.
No.
Dr. Bechtel.
No.
And myself, Michael Schottenstein, yes. Thank you all. In the following matter, the board issued a notice of opportunity for hearing. No timely request for hearing was received. The matter was reviewed by a hearing examiner who prepared proposed findings and proposed orders, and it's now before the board for final disposition. This matter is disciplinary in nature, and therefore the secretary and supervising member cannot vote. In this matter, Dr. Rothermel served as secretary, and Dr. Safran served as supervising member. Please turn to the matter of Kurt Elliott Liebman, MD. Do I hear a motion to find that the allegations as set forth in the November 13th, 2019 Notice of Opportunity for Hearing in the matter of Dr. Liebman has been proven to be true by preponderance of the evidence, and to adopt Ms. Lee's proposed findings and proposed order? Motion, please.
So moved.
Ms. Montgomery and
Second.
thank you so much. I will now entertain discussion concerning the matter of Dr. Liebman. Is there any discussion? Okay, hearing none. Roll call vote then, please, to approve and confirm the proposed findings of fact, conclusions, and order as presented in the matter of Dr. Liebman. Dr. Rothermel,
Abstain.
Dr. Safran,
Abstain.
Mr. Giacalone,
Yes.
Dr. Sohn,
Yes.
Dr. Johnson,
Yes.
Dr. Cacarella. Yes. Mr. Gonadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Farber,
Yes.
Dr. Bechtel,
Yes.
and myself, Michael Schottenstein, yes. Thank you. In the following matters, the board issued notices of opportunity for hearing and documentation of service was received for each. There were no timely requests for hearing filed, and more than 30 days have elapsed since the mailing of the notices. These matters are therefore before the board for final disposition. These matters are non-disciplinary in nature, and therefore all board members may vote. On February 18th, 2020, the board issued a notice of opportunity for hearing to Antonio S. Cruz, Jr., MT, informing him that the State Medical Board of Ohio proposed to deny his application for a certificate to practice massage therapy because he does not hold a diploma or certificate from a school, college, or institution in another state or jurisdiction that meets the board's required course of instruction, and hasn't held a current license, registration, or certificate of good standing for massage therapy in another state for at least the preceding 5 years. Do I hear a motion to find that the facts set forth in the February 18th, 2020 notice of opportunity for hearing have been proven to be true by preponderance of the evidence, and that the board enter an order effective immediately upon mailing denying Mr. Cruz's application? Motion, please.
So moved.
Wow, my goodness, Dr. Bechtel, and sorry, who then? Dr. Johnson, thanks so much. Is there any discussion concerning the motion? Okay, roll call then, please. Dr. Rothermel,
Yes.
Dr. Safran,
Yes.
Mr. Giacalone,
Yes.
Dr. Sohn,
Yes.
Dr. Edgin. Dr. Edgin, that's not right. Dr.
Dr.
Johnson,
Johnson.
yes.
Yes.
Thank you. Dr. Cacarella. Was a yes. Mr. Gonadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Fleibel,
Yes.
Dr. Bechtel,
Yes.
and myself, Michael Schottenstein, yes. Thank you.
Yeah, Dr. Schottenstein, I apologize. It looks like Dr. Edmonds' name got carried over on the roll call motions for the Cosby's. But if he had not, there's not a replacement, so if you just skip over that, the order will stay the same. I apologize for the confusion.
Not to worry, of course. I'll just skip over going forward. On February 18th, 2020, the board issued a notice of opportunity for hearing to Aaron F. Fletcher, MT, informing him that the State Medical Board of Ohio proposed to approve his application for license to practice massage therapy, provided that he take and pass the massage and bodywork licensing examination NBLEX, due to the fact that Mr. Fletcher has not engaged in the active practice of massage therapy for more than 2 years. Do I hear a motion to find that the facts set forth in the February 18th, 2020 notice of opportunity for hearing have been proven to be true by preponderance of the evidence, and that the board enter an order effective immediately upon mailing, approving Mr. Fletcher's application provided he takes and passes the NBLEX within 6 months of the date of mailing of the order? Motion, please.
So moved.
Dr. Bechtel, thank you. And second,
Second.
Dr. Sohn, I think. Thank you. Is there discussion concerning the motion? Roll call, please. Dr. Rothermel,
Yes.
Dr. Safran,
Yes.
Mr. Giacalone,
Yes.
Dr. Sohn,
Yes.
Dr. Johnson,
Yes.
Dr. Cacarella,
Yes.
Mr. Gonadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Fleibel,
Yes.
Dr. Bechtel,
Yes.
and myself, Michael Schottenstein, yes. Thank you. On February 18th, 2020, the board issued a notice of opportunity for hearing to J.A. Garnier, RCP, informing him that the State Medical Board of Ohio proposed to approve his application for a license to practice respiratory care, provided that he take and pass the clinical simulation examination, CSE, due to the fact that Mr. Garnier has not engaged in the active practice of respiratory care for more than 2 years. Do I hear a motion to find that the facts set forth in the February 18th, 2020 notice of opportunity for hearing have been proven to be true by preponderance of the evidence, and that the board enter an order effective immediately upon mailing approving Mr. Garnier's application, provided that he takes and passes the CSE within 6 months of the mailing of the order? Motion, please.
So moved.
Second.
Thank you, Dr. And Dr. Bechtel, thanks very kindly. Is there any discussion concerning the motion? Okay, roll call, please. Dr. Rothermel,
Yes.
Dr. Safran,
Yes.
Mr. Giacalone,
Yes.
Dr. Sohn,
Yes.
Dr. Johnson,
Yes.
Dr. Cacarella,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Bechtel,
Yes.
and myself, Michael Schottenstein, yes. Thank you. On February 18th, 2020, the board issued a notice of opportunity for hearing to Francis M. LaRocca, MT, informing him that the State Medical Board of Ohio proposed to approve his application for restoration of his license to practice massage therapy, provided that he take and pass the Massage and Bodywork Licensing Examination, MBLEX, due to the fact that Mr. LaRocca has not engaged in the active practice of massage therapy for more than 2 years. Do I hear a motion to find that the facts set forth in the February 18th, 2020 notice of opportunity for hearing have been proven to be true by preponderance of the evidence, and that the board enter an order effective immediately upon mailing, approving Mr. LaRocca's application, provided that he takes and passes the MBLEX within 6 months of the date of mailing of this order? Motion, please.
So moved.
Dr. Safran, thank you. And Dr. Bechtel, thank you so much. Is there any discussion? Roll call, please. Dr. Rothermel,
Yes.
Dr. Safran,
Yes.
Mr. Jackalone. Mr. Jackalone was a yes? Sorry.
Yes.
And Dr. Sloan,
Yes.
Dr. Johnson,
Yes.
Dr. Kakarala,
Yes.
yes. Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Bechtel,
Yes.
and myself, Michael Schottenstein, yes. Thank you. On February 18th, 2020, the board issued a notice of opportunity for hearing to Liua Anita Yang, MT, informing her that the State Medical Board of Ohio proposed to deny her application for a certificate to practice massage therapy because she does not hold a diploma or certificate from a school, college, or institution in another state or jurisdiction that meets the board's required course of instruction and hasn't held a current license, registration, or certificate of good standing for massage therapy in another state for at least the preceding 5 years. Do I hear a motion to find that the facts set forth in the February 18th, 2020 notice of opportunity for hearing have been proven to be true by preponderance of the evidence, and that the board enter an order effective immediately upon mailing denying Ms. Yang's application? Motion, please.
So moved.
Dr. Safran and
Second.
Dr. Bechtel, thank you. Discussion? Roll call, please. Dr. Rothermel,
Yes.
Dr. Safran,
Yes.
Mr. Jackalone,
Yes.
Dr. Sloan.
Yes.
Thank you. Dr. Johnson,
Yes.
Dr. Kakarala,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Bechtel,
Yes.
and myself, Michael Schottenstein, yes. Thank you. I will now entertain a motion to go into executive session to confer with the medical board's attorneys on matters of pending or imminent court action, and for the purpose of deliberating on proposed consent agreements in the exercise of the medical board's quasi-judicial capacity, and to consider the appointment, employment, dismissal, discipline, promotion, demotion, or compensation of a public employee or official. Motion, please.
So moved.
Dr. Safran, thank you, and
Second.
Second.
thank you so much. Roll call, please. Dr. Rothermel,
Yes.
Dr. Safran,
Yes.
Mr. Jackalone,
Yes.
Dr. Sloan,
Yes.
Dr. Johnson,
Yes.
Dr. Kakarala,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Bechtel,
Yes.
and myself, Michael Schottenstein, yes. The time is now 12:07 p.m. and the board is in executive session.